Companies Act, Section 239, Preservation of Books and Papers of Amalgamated Companies. Section 239 of the Companies Act, 2013 focuses on the preservation and protection of records, documents, and papers belonging to a company that has either been amalgamated with another company or whose shares have been acquired under the provisions of this chapter. The intent of this section is to ensure that these documents are not prematurely destroyed or tampered with, particularly when they may contain evidence relevant to the investigation of offenses related to the company's past conduct, management, or formation. This provision serves a regulatory and investigative purpose, empowering the central government to prevent the disposal of important records until it has had the opportunity to assess whether those documents contain material that warrants scrutiny or legal action. Key provisions explained. 1. Applicability to amalgamated or acquired companies. This section applies to companies that have been amalgamated with another company or have had their shares acquired by another company under the relevant provisions of the Companies Act, 2013, especially under Chapter 15, which governs compromises, arrangements, and amalgamations. Once such a transaction has taken place, the question arises as to what should be done with the books and papers, which include statutory records, registers, correspondence, meeting minutes, financial statements, contracts, and other official documents of the transferor company. 2. Prohibition on disposal without prior government approval. The section expressly prohibits the disposal or destruction of the books and papers of the transferor, amalgamated or acquired, company without first obtaining the prior permission of the central government. This means that the books and records must be preserved intact, even after the company has ceased to exist as a separate legal entity due to amalgamation or acquisition. No authorized signatory, director, officer, or new management of the transferee company can discard these records unilaterally, and a formal application must be made to the central government, seeking its approval before any such action is taken. This safeguard exists to ensure that important documentary evidence is not lost or destroyed before a thorough review can take place. 3. Power of the central government to appoint an examiner. Before granting permission to dispose of the records, the central government has discretionary powers to appoint a person, which may include a government officer, inspector, or other designated authority, to examine the books and papers in whole or in part of the amalgamated or acquired company. The purpose of this examination is to ascertain whether the records contain any evidence of an offense committed by the company or its officers, specifically in connection with the promotion or formation of the company, or in relation to the management of the company's affairs, or in connection with the process of amalgamation or share acquisition. This examination is essentially a precautionary and investigatory mechanism that enables the government to uncover any wrongdoing or malpractice that may have occurred during the lifetime of the original company. Purpose and importance. This section reflects the legislature's intention to preserve evidence that may be relevant to future regulatory or legal actions, prevent tampering, loss, or destruction of important corporate documents that could be used in prosecutions or investigations, ensure corporate accountability, particularly in the context of mergers, takeovers, or restructuring that may have been executed with fraudulent or unlawful intent, and facilitate the investigation of white-collar crimes, including financial fraud, mismanagement, or violations of corporate law. By empowering the central government to intervene before any disposal of records, the provision also reinforces corporate transparency and discourages misconduct during the process of amalgamation or acquisition. For more details, contact us.